Let's bring in CBS News legal contributor Jessica Levinson to talk about what we've heard so far and what we can expect for the rest of the day. So, Jessica, I was really intrigued listening to Senator Graham question Judge Jackson. Specifically, I was curious about what he was going after when he was asking her about her time as a public defender and her work with detainees at Guantanamo Bay. Give me a sense of what he was trying to get out of her, and how do you think she responded? Do you think that that was sufficient for Senator Graham, although he did say that he was confused by her answers, and to be fair, it did sound as if she was sort of dancing around his direct line of questioning.
Right. I would say following in decades of Supreme Court nominees who are basically explicitly told that the way to have a good performance in the confirmation hearings is to dance around some questions. So I think what he was trying to do is tie her to unpopular people and or positions. So particularly when he talked about her work as a federal public defender, he's trying to say, so aren't you soft on crime? When he's talking about her work as a federal public defender, he's trying to say, so you supported these people, these criminals. Of course, I'm paraphrasing here. And then when he's moving on to this idea of her filing amicus briefs as a lawyer in private practice, with respect to the Guantanamo Bay issues, he's trying to say, so you called the American government war criminals. And so that's your position, right? I would say in all of those lines, we have a similar bottom line, which is it's a misunderstanding of what lawyers in the American system do. The American system depends on lawyers to zealously advocate for their clients, whether that be as a federal public defender or as a lawyer in private practice. That doesn't mean that they hold the positions of their clients, and that's a really important distinction. I
was just going to say that. I mean, that is sort of. I've been watching along with social media by prominent attorneys on social media who are essentially saying what you just said, Jessica, which is here's Judge Brown explaining to Lindsey Graham, who is a lawyer, how lawyers actually work in this country.
So.
Oh, I'm sorry.
No, I was going to actually sort of pivot a little bit because sort of when you talked about, you know, in order to have a good performance, you have to dance around certain questions. And there's an expectation that we're going to see certain lines of questioning. And Lindsey Graham sort of picked up right after this explanation of what lawyers do, picked up with her judicial philosophy, which we also knew was going to come up. And once again, he tried to sort of pair it with something else. He identified, I guess, groups that he considers sort of left-leaning groups and how they were enthusiastic supporters of her. Of course, he was an enthusiastic supporter of her.
I mean, I would have said, that's what I would have said. You also were an enthusiastic supporter of mine.
And so, you know, her response, I thought was kind of interesting that she said, you know, she didn't have a judicial philosophy. She had a methodology. This is a question that most nominees have to figure out a creative way of answering without being pinned down. What do you think of her answer?
So a couple of things. I actually think her answers today, frankly, probably won't change the outcome. We're just looking at whether or not she's going to be able to retain those 3 Republican senators who voted for her less than a year ago for the D.C. Court of Appeals. So it sounds strange to say because it's so high stakes and it's so important to listen to how she answers, but I'm not sure it's going to change any senator's vote. You know, when it comes to these questions of how she answers, I think she's actually doing a good job and a creative job of saying it's not an ideology, because people tend to get really nervous when they hear words like ideology. Oh, suddenly this means she's an activist. Suddenly this means she's really a politician. She's not actually a judge. And she's gone to pains all morning to say a few things, that I'm very constrained. And she actually used the words, I have to stay in my lane. And I think to pick up on your question, that's really what she was saying with this, I have a methodology, right? She's saying, I'm constrained by what the third branch can do, what the judiciary can do. I'm constrained by what precedent says that I can rule on and what I can say. And she's saying, and I'm constrained in the sense that I look at the facts and I look at the law. I don't have this bias. I don't have this bent. I don't have this ideology. I don't know, you know, who exactly the audience is for that, because again, I don't know that she's going to change a lot of minds, but I think it's a really smart way of answering this unanswerable question.
All right, let me ask you about something else that I thought was interesting. Republican Senator Chuck Grassley opened by asking Judge Jackson about the right to bear arms and whether or not she believes the right to bear arms is a fundamental right. I want to play some of her response.
Senator, the Supreme Court has established that the individual right to keep and bear arms is a fundamental right.
Could you tell me how you might go about deciding what a fundamental right is under the Constitution?
Well, Senator, I don't know that I can tell you that in the abstract in the sort of way that you may have posed the question. There is precedent in the Supreme Court related to various rights that the court has recognized as fundamental. The court has some precedents about the standards for determining whether or not something is fundamental. The court has said that the 14th Amendment substantive due process clause does support some fundamental rights, but only things that are implicit in the ordered concept of liberty or deeply rooted in the history and traditions of this country. They're the kinds of rights that relate to personal, individual autonomy, and they've recognized a few things in that category, and that's the tradition of the court for determining whether something is fundamental in that way.
All right, thoughts on that line of questioning from Senator Grassley and then her response, Jessica?
I just had this conversation with my constitutional law students, which is how do you determine whether or not a right is fundamental? And I'm going to be completely transparent that what I said to my students is kind of a plain English version of, I think, what she said, which is she used words like ordered liberty. It's, recognized as a foundational concept. And the answer is that whatever the justices say is really, really important, we can find under the substantive due process clause should be recognized as a fundamental right. And I think what Senator Grassley is trying to get at is, don't you actually have an enormous amount of power as a Supreme Court justice to exercise your discretion, to exercise your own judgment, to do things like read new fundamental rights that are not enumerated, that are not listed into the Constitution? And what she's saying is, again, back to her theme of no, I'm limited, no, I'm constrained. And she's saying, well, yes, but I have all these guideposts. I have to follow these guideposts. And so I think her answer does, and you could see her being so careful in how she responds, but I think her answer does a good job in saying, don't worry, I'm not going to make things up. I'm not going to rewrite the Constitution. And that's what I think that whole exchange is about, which is, are you going to stay with the text of the Constitution, or are you going to be one of these, again, quote unquote, liberal activists that just writes your own definitions into the Constitution?
So then, Grassley followed up with when he asked Judge Jackson about the Second Amendment being a fundamental right, which she said it is based on Supreme Court precedents. He then asked her, well, how do you decide what a fundamental right is? What kind of question was that? What was he getting at?
So he's getting at, again, this idea of that justices sometimes make decisions and often have to make decisions based on what they think the Constitution is guiding them to say. So there's a lot that's not written in the Constitution in kind of black and white, bright line rules. So for instance, this idea of substantive due process, this idea of fundamental rights, if it's not written in the Constitution, we understand that justices have some discretion, some leeway to say, we're going to decide that this particular right is in fact fundamental, that that's part of what they do when they're deciding cases. And Grassley's trying to say, are you going to tether yourself to the Constitution, or are you going to be an originalist? Are you going to be a strict constructionalist? And what Judge Jackson is saying is, I have these guideposts that I have to stick with. Don't worry, I'm not going to, go rogue. I'm going to stay within the confines of my job.
It's actually quite fascinating to watch it. We've watched several others now, confirmation hearings, and some of them are a few more fireworks than others. It's still very, very fascinating watching the process unfold.
But I also wonder, and we're not lawyers, so that's why we're so happy that you're here, Jessica, that, in the kind of questions that we hear from from both Republicans and Democrats. I mean, Senator Grassley asking about the Second Amendment, what's she going to say?
I know.
You know, or asking her, do you think that the First Amendment applies to both liberals and conservatives? The answer for even somebody who's not a lawyer is yes.
Yes, yeah. Well, the part of what we have to accept is that this part of the process is a little bit about performance.
Right.
We know that they're going to be asked very similar questions, and we know that the job of the nominee is to, you know, not say anything too controversial and not take a vote away from them.
That's right.
So,
That's right.
Jessica, thank you very much.
Thank you.